Education Fund is dedicated to educating the public and professionals in our business with fact-based information, featuring the experts in our profession so that we all might do a better job of helping college athletes realize the promise of an educational degree and becoming all they can be as students and athletes, and the athletics administrators who are managing these programs. So we welcome you to our 40th webinar. Lastly, thanks to all of our panelists today for their time, expertise, and ideas, and to all of you attending. Webinars provide us with the opportunity to share new ideas, recalibrate our thinking on issues, and get up to date on important topics. We're so pleased to have you join us. Before you meet our moderator and panelists, I just want to emphasize our speakers are expressing their own opinions and not the opinions of the organizations in which they are employed or are members, unless they make that distinction in their remarks. And I'm honored to introduce the moderator of today's program. Please meet Luke Fedlam, partner and head of the Sports Law Practice Group at Porter, Wright, Morris, and Arthur, LLP, and thought leader on the issues impacting college sports.
Awesome. Thank you so much, Julie. Let's just get right into it because, as you mentioned, there is so much to talk about and such a great and important topic that we're going to be getting into today. When you registered for the webinar, you received the biographies of all of our amazing panelists, but I want to just thank and briefly acknowledge our panelists before I begin asking questions and diving right in. So James Bryant, founder, chairman of the National Litigation Law Group; Amanda Kristovich, reporter from Front Office Sports; Jema Meyer, counsel at Simpson, Thacher, and Bartlett; and Andy Zimbalist, the Robert A. Woods Professor Emeritus of Economics at Smith College. We are excited. I'm excited, and I know we as a panel are excited for this conversation that we're going to have today on, as I said, a very important topic as we look at this proposed settlement in this House case. I know that a lot of you as attendees maybe already have a sense of what the settlement is, but I think a great place to start is just to ensure that we're all on the same page with a high-level overview of really what the settlement is. And for that, Jema, I'm going to turn it over to you to just give us a sense of what are we talking about here with the settlement.
Thank you, Luke. And thank you to the Drake Group for giving me once again the opportunity to participate in your webinar. This settlement that is proposed and that is on shaky legs right now truly will reshape intercollegiate sports. So I think it's especially important that we're covering it today. I'd like to talk almost in generalities and avoid legal jargon today so that we can truly grasp the fundamentals of what's going on here. The settlement agreement itself is 133 pages, so clearly we don't have time to get into all of the nuances. What are we talking about here? So there are three cases at issue. There's the House et al. Case, the Hubbard et al. Case, and the Carter et al. Case. These have been sort of combined in various configurations with respect to the proposed settlement agreement or agreements, really. In each of the cases, the NCAA and the Power 5 conferences have been sued. So the individual schools have not been sued. These are antitrust cases. Only in the House case have the classes actually been certified. You know, there's been briefing in some of the others, but the classes were not actually certified. And the classes vary slightly in each of the cases. So that's sort of the broad brush picture of the cases. So for months now, we've been hearing about a proposed settlement in the three cases. Originally, we just had a term sheet, which that was being discussed, and that wasn't even publicly disclosed. And so much more recently, the full agreement, the parties had to file the full agreement with the court. And the court set up a hearing for preliminary approval, which is what you need to do in a class action. The parties can't just go off and settle on their own. The court in a class action has to actually approve the agreement. Well, 2 weeks ago or so, there was a 2-hour hearing before Judge Wilkin, who, by the way, was also the judge in the Northern District of California for some of the previous antitrust cases against the NCAA, including O'Bannon and Alston. So she's pretty familiar with what goes on in college sports and the whole compensation issue. And these cases all are about getting more benefits to athletes, and particularly cash benefits. I just want to make that clear. They're called different things. They have different labels, but whether it's NIL payments, whether it's academic awards, athletic awards, pay for play, it's all, despite the label, it's about getting more cash to athletes. And there are three main aspects of the settlement. And again, I'm speaking in generalities, okay? Past damage award, future injunctive relief, and changes to the roster and scholarship limits. So let me very, very briefly talk about those three categories, but we'll get into them in greater detail, I'm sure, in the next hour and a half. So back damages. $2.8 billion is going to go to athletes for back damages for missed payments, so-called missed payments that, but for the NCAA rules that prohibited those payments, athletes would have received. Most of the money is attributable to broadcast NIL payments that the plaintiffs allege would have gone to athletes if the NCAA rules had permitted. An important point here that we will talk about later is that 90% of that amount of money will go to male athletes. Second category is the injunctive relief. The injunctive relief provides for schools to be permitted to pay in 2025 or more than $20 million in rev share to athletes. This amount it applies to a 10-year period. It will escalate depending on the revenues of the average Power 5 schools. It's pegged into the revenue. Again, it's not clear for what label will get attached to the cash payments to the athletes or how much will end up going to whom. But now the schools will be permitted for the first time, despite the amateurism rules in the past, to share their revenue with athletes. The third category, which is minor compared to those two, but nonetheless important, is that the agreement does away with scholarship limits. No longer will there be limits in the Power 5 and Division I as to how many scholarships must be given per sport, but there will be now roster limits. So that also has implications as to how the schools implement that. There are no particular requirements in the settlement agreement as to what they must do, although there are some limits on the rosters now in terms of, like, baseball now has increased enormously. So that will also have implications on females, and we'll get into all of that later. So I think now it's probably best to think about those three things as we go forward and think about where the money's coming from and whom's going to, and how schools are going to comply with this, because there are some really big questions.
Really big questions. Absolutely. Thank you, Jema, for that. And one of those questions that you just mentioned, right, is where is this money coming from? And so the NCAA a few weeks ago put out a memo to all of its Division I conferences, kind of providing some details as to what that distribution for the back pay portion, that nearly $2.8 billion that Jema mentioned, where is that coming from? And there is a significant portion that's coming from the NCAA, around over $1 billion, but around 1.5 billion or so that's going to end up being split in different percentages between the Power 5 conferences that are named in the House suit, but also the 27 other non-Power 5 conferences that exist. So James, Brian, I want to kind of turn over to you for a second, because you represent Houston Christian University, who filed a formal objection to the settlement based really on the inequitable financial burdens for schools that are outside of the Power Five. So I'm just curious if you could share with all of us kind of why file the objection, what was the judge's decision, and then what was some of the reasoning behind that decision?
Thank you very much, and it's an honor to be a part of this seminar and webinar today. I welcome Dean Peter Gopperu's sports law class in Florida, who's dialed in. But the more time I spend on this case, the more I think we ought to be dialing in the civil procedure classes too, because this case would make a good bar exam or final exam in civil procedure. So I do represent Houston Christian University. It's a small Division I school that transitioned from the NAIA. We didn't technically file an objection, but we asked the judge to let us intervene. And we couldn't file an objection technically because we weren't a party, which is the first part of the confusion of the civil procedure. Is our institution is getting ready to be bound by a decision we are not a party to. And under the intervention statutes in federal court, we thought we easily had an absolute right to intervene because the standard is that we are affected. And this is an opportunity to speak to how we are affected. The judge disagreed, but it's really hard to lose a permissive intervention, which we also lost, which all the courts and appellate courts favor granting. People have the right to be heard. It's the fundamental element of due process. But our objection centered on several things. One, as has been mentioned, the disparity in damages. But even more fundamentally, we believe that the settlement and the litigation has ignored the economics in Division I sports. There has been this presumption that money needs to be divided, profits need to be divided, which in fact, Division I sports is hemorrhaging in multi-million dollars, $1 billion worth of losses. And as a result of that, the price to pay for this lawsuit and the fervor we pursue Division I sports is borne by the students. Student debt continues to go up, student loans continue to go up, attrition continues to increase. And we also raise the issue that we believe our board has the fiduciary duty to not be involved in the settlement because it's pulling money from our academic mission. And what's strikingly dramatic to me in talking to our academic administrators, the people hurt the most by this settlement are our African-American male students who are not athletes, our other people of color, and our immigrant students. And Houston Christian University is the most diverse private college in America. And we have to find $3 million to put back in the budget because of this settlement. By contrast, and I won't name names, but one of the most profitable Division I basketball programs in America is contributing $1 million. So there is a disparity, but we thought there was a greater issue that the fiduciary duties of the boards were called into question by this settlement. But most fundamentally, we thought we had the right to be heard. And again, the reason it's a civil procedure confusion is we weren't sued. Our conference wasn't sued. And we believe it's pretty clear that the NCAA had no authority to settle this case without a membership vote. So it's a head scratcher, and the judge disagreed on all counts, and I think was frustrated that we tried to intervene, and that's where we're at.
Well, you bring up some of the financial disparity and the financial challenges. Another disparity and challenge that Jayma brought up earlier was just around Title IX and gender equity as it relates to this proposed settlement. I want to maybe shift our conversation there a little bit to just think about kind of, it's not just the male athletes that are suing the NCAA under these antitrust violations. So Jayma, I want to come to you first, but then I want to also get Andy and Amanda's perspective on this. But can you talk more about the Title IX objections that we are hearing, and then whether it's an issue in this settlement, and if so, kind of why is Title IX an issue? And you kind of teased it a little bit earlier, but let's dive into those weeds a little bit.
Okay, terrific. And one thing I would like to add that I know I wasn't clear on is that there was a hearing on the preliminary approval 2 weeks ago, and most people thought that it would be rubber stamped, that the court would preliminarily approve this proposed settlement, and then there would be more objections during the next, it's going to be 4 or 5 months from others. But we're going to talk about, in addition to the objections that James made on behalf of HCU, other objections. And one of them was made, another objection was made by female athletes. But I want to make it clear that Judge Wilkin did not rubber stamp this. And she sent the parties back to the drawing board and said, here, there are a number of concerns. And we'll talk about those concerns. But one concern that she didn't seem to have, despite it being raised, is Title IX. She was somewhat dismissive in saying, this is an antitrust case, and I'm not going to talk about Title IX, despite the fact that there are clear Title IX impacts here in the way that the money's being distributed. Maybe I should back up for 1 second. And what is Title IX? Title IX prohibits sex discrimination in educational activities. And when it comes to athletics, there are 3 criteria that are typically applied to evaluate whether an entity is in compliance with Title IX. And all 3 of these come into play in the proposed settlement. The first is there must be equal opportunity to participate. So if the school has 60% women, then 60% of the athletic opportunities must go to women. The second one is proportionality with respect to scholarships, so that if 60% of the athletes are women, then 60% of the financial assistance must go to women. And lastly, the third criteria is that treatment and benefits must be equitably provided. So those are the 3 main evaluation criteria for Title IX compliance. And here, let's just step back and not get into the legal jargon again. If you've got 90% of the dollars in past damages going to men, or if the average football player and men's basketball player is going to receive $135,000, with the average woman basketball player receiving $35,000, I mean, just step back. That is not equitable. We don't have to get into the very specifics, in my mind, as to whether there's Title IX compliance. But I think it's important here, if you want to break it down into those categories, if you really think about how are you going to classify the cash? And the NCAA, in litigating the House case, said that the model for distributing the money from broadcast, and again, the NIL rights, and again, that's the biggest chunk of the settlement with respect to past damages. The NCAA said this qualifies as financial aid, treatment, or benefits. It qualifies as all 3. Therefore, either if it's financial aid, then it has to be substantially proportionate to the number of athletes, or if it's benefits equitably. And that is just not happening with respect to either past damages. And we can talk about what the defenses are maybe a little bit later. I don't want to monopolize this. And with respect to future damages, we don't know how the schools are going to pay the athletes, the means, or whom will receive how much and what sort of criteria they will apply. Will they decide that, all right, the football players bring in more revenues and therefore we're going to, there's some kind of, defense that allows them to do that? Well, no, there's not, but that's what they're trying to get at. Or will they decide, all right, if we give this, the same number of athletes some money, it doesn't matter that the dollar amount is much greater for the men. So there are these big issues, and that we can come back to, because I would love to just, get into why I do think that Title IX needs to apply to these in terms of the dollar amount, and there's no defense for revenue sharing or marketplace realities in Title IX. The Congress made that very, very clear for a number of years when a number of proposals were made to exempt football and men's basketball from Title IX. But so the thing that's most important to me now is that schools are coming up with their budgeting. They're recruiting now. Athletes now are deciding where they're going to go based on how much money they're getting.
Sure.
Yet there's no clarity. We need clarity. So I'll pass the ball, but we can come back to some of the more specifics.
Absolutely, thank you, Andy. We're talking about money and money flowing, and you're an economist, so you're a great one to kind of bring this part of the conversation. We're going to get into the broader economics here in a little bit, but from a Title IX perspective, what are your thoughts here?
I agree with Jema. I think that Wilkin is being very narrow-minded, and she's being blinded by her antitrust silo. And the problem is we're dealing with a beast here, the ecosystem of college sports, that is much more broadly affecting the society beyond any monopoly restraint of trade types of claims. So in this case, Title IX is very clear when it talks about equitable treatment of women. It doesn't say that you can give women less if they earn or if they produce less money. There's no such concept within Title IX. And as a consequence, it's necessary, I think, when you have a compensation system put in place, that it not be based upon some notion. Nobody really knows how much the men are generating versus how much the women are generating. Of course, the men have generated a lot more television revenue than women have, in large part because the men's sports have been promoted and the women's sports haven't. We can see when the women's sports get promotion through Caitlin Clark and Angela Reese, what happens to the revenue generated. But never mind, we're not supposed to look at revenue generation when we decide that women deserve equal treatment. And that's not being done here. And Wilkin can say, okay, it's not my business because it's an antitrust. It's a Title IX case, not an antitrust. Maybe some aggrieved women need to bring litigation against the settlement. Maybe you can't resolve it entirely within the antitrust settlement. I think you ought to be able to, but if you can't, then I think there should be some other independent action going on. Beyond that, there are some very large economic questions with the settlement. One of them pertains to going forward, this notion that schools can use up to 22% of the average revenue in Power 5 schools to compensate athletes or to revenue share with athletes. That's an expensive proposition. It's an expensive proposition that I think only the Big Ten schools are going to be able to handle with any kind of aplomb. I think that the SEC is going to be in trouble. And the ACC and the Big 12 are going to be in even more trouble. And of course, in even greater trouble will be the FCS schools and the Division I schools without football. So it's a very serious matter. Not only do you have the asymmetrical harm being foisted upon the other 25 conferences in Division I, but you have some very serious harm that will affect some of the Power 5 schools. So that 22% is going to bring on about an additional $21 million of cost to the schools that opt into the system. And most of the Power 5 schools, at least initially, are going to feel competitive pressure to opt into that system. As James alluded to, for the Power 5 schools, they're going to have about a $1 million reduction in distributions from the NCAA because of the past settlement. So we have a $22 million load there that they have to carry. Some of that will be abated because certain payments, like Alston payments, will be allowed to be included in that, or will necessarily be included in that 22%. Now, beyond that, as Jema mentioned, scholarship limits have been removed. All we have now is roster limits. And so in the past, as an example, you could give full scholarships to 85 football players. Now you'll be able to give full scholarships to 105 football players. And there's going to be similar increases. In some cases, like baseball, be even a larger proportionate increase. There'll be increases in scholarships for the other sports as well. The AD at University of Tennessee just came out with an estimate that those increased scholarships are going to cost the school an extra $10 million a year. So now we're not only talking about the 22% and the $22 million, but here's another $10 million. Now, fortunately, the NCAA has signed a new television contract. It's going to bring about, and the numbers here are not entirely clear, but it's going to be about another $20 million in revenue annually to the Big Ten schools because of their new contract. So that will enable them to deal with a large part of that. And there's also the expansion of the college football playoff. And that's going to bring an extra $10 million roughly to each of the Power 5 colleges. So I think in the case of the Big Ten, because of the very rich television contracts they have and because of the expansion of the CFP, I think the Big Ten schools basically are going to find a way to work in this new system. I think everybody else has either additional problems that are significant or massive problems that, as James pointed out, will deleteriously impact the educational system in their school.
Yeah, absolutely. So two things that I'll add to that. I think as moderator, I get to be player coach every now and then, so I get to jump in and add my thoughts. And one thing I'll say that's important is everything that we're talking about is still part of the proposed settlement, and we know that the parties are going back to work on this. I bring that up because sometimes I'm having conversations where people believe roster limits now have already changed, or scholarship limits have already changed. And so we want to make sure this is still part of this proposed settlement that we're seeing. But the other thing, Andy, to your point, you brought up, Tennessee and talking about the cost. Well, Tennessee also came out to say, hey, we're going to have a 10% surcharge if we have to come up with these fees on our tickets and things like that. So the money's going to have to come from somewhere. And so if you're also a fan of college sports, in addition to maybe working in or caring about college sports, you're going to probably carry some of the burden of this cost as well. Amanda, I want to come over to you real quick for two reasons. Andy talked about kind of this asymmetrical impact of the financials. James has talked about the Title IX aspect of things. You've researched and you've written a lot on Title IX for front office sports. I just want to get your thoughts as you hear this and as you are interviewing and talking with people across the industry. What are you seeing as it relates to these kind of two areas, and what are your thoughts there?
Yeah, I think with regards to Title IX, I'm obviously sitting in a different seat than the other brilliant panelists because I'm reporting on the issues rather than being an expert in them. So really, I can just tell you what I think are a couple of the interesting, and these were alluded to earlier, the sort of counter arguments and the conversations that happened in the during this 2-hour hearing. By the way, it was like almost 3 hours. Okay, it was longer than 2 hours. I know this because I'm on the East Coast, and it started at, when did it start? 5:30 p.m. Eastern. Anyway, so as was alluded to, Judge Wilkin basically said, and it almost sounded like the sort of attorneys were agreeing with her, like this is a case where the damages, both the injunctive relief and and the back damages, are based on the economic realities. And the economic reality is that the NCAA, as we all know, has systematically devalued women's sports, female athletes, for all the 50 or so years that it has overseen women's sports. So they were sort of saying, and Judge Wilkin was saying, come back with a different lawsuit. And it was interesting. One of the attorneys for the plaintiff, Steve Berman, made a comment saying, I tried 2 or 3 times to get this into the lawsuit about, the gender equity issue, and I couldn't. So perhaps somebody else, could start some new litigation or even challenge the settlement. And what I found to be so interesting about that was Judge Wilkin didn't say, like, she sort of was like protecting this settlement in a way from the Title IX issues. However, she made it very clear that she wants a list of issues that the settlement does not protect the NCAA, the conferences, and the schools from in the future. And that includes Title IX. Like, she basically said, I need you guys to add somewhere that, the distribution of the $22 million, if it, if there's a scenario in which a female athlete challenges this distribution model, because her school only offers an inequitable amount of that pot to female athletes, and if that's found to violate Title IX, Judge Wilkin wants it in the settlement that that school can be challenged, and this settlement doesn't save them from that. So I think, like, that's, to me, that was the most important thing, right? Because ultimately, what was difficult, and I think is probably difficult for all of us about watching, these settlement conversations unfold, is they're unfolding, as a settlement to a class action lawsuit, but they're being treated like a collective bargaining agreement or future of college sports roadmap. That's not, like, again, you guys are the lawyers, but, like, it doesn't sound that illogical to me that if this is strictly an antitrust case, there are going to be other issues, because this one settlement cannot solve, or, college, every single issue in college sports. And then this was another issue that was brought up, which I'm sure we'll get to, is the question of, is this being used as a collective bargaining agreement, which of course has its own implications. And I think that really speaks to, especially the Houston Christian question. I spoke with a lot of conferences who are very angry about the settlement when it first came out, but have since sort of been told to kind of be quiet, fall in line. Having a settlement where you have to lose distributions is better than, not settling at all. Trust me, said Charlie Baker, wink, wink, hint, hint. So I think that, because this is not a collective representation on either side, right, of Division I from the defendants or of the athletes from the plaintiffs, that's why we're running into all these issues and all these, like, extraneous questions.
Can I pursue something there, Luke?
Yeah.
Because Amanda brought up collective bargaining, and I think and I want to hear from the three lawyers on our panel about this. It strikes me that Kessler and Berman have no business introducing a cap on payment. The reason why the NHL and the NFL and the NBA and MLS can have a cap on revenue to pay the players is because they have unions and they have collective bargaining, and hence they are subject to the non-statutory labor exemption. And it enables them to bargain for a cap. But there is no union here, and there is no collective bargaining here. They're self-appointed leaders of Jeffrey Kessler and Steve Berman, who are bargaining on behalf, so one would assume, on behalf of the players. But where is the legal backing for them to be able to do this, let alone any ethical or philosophical rationale?
Yeah. Andy, you can be player coach too, man. This is a great question. I'll give you my perspective, and then James and Jama, I'd love for you to chime in on that particular question, because I think that's one of the issues that I see in all of this, right? And if we look at the Alston case, right? The Alston case said that ultimately the question before the court is it an antitrust violation for the NCAA to have caps on education-related benefits, right? And ultimately, unanimously, the court said that it is. And this idea then that there's now a negotiation, right, as part of the settlement to specifically put in a cap, especially when, which we're going to get into next, kind of after people answer this question, we're going to get into this notion of what Judge Wilkin saw as some of her bigger issues, the biggest issues that she identified as some of the challenges. But I think, the cap of saying 22%, that was something that really was, that just doesn't sit well with me, given where the court has already been here recently in terms of not having these limitations on student athletes. What say you, James? You're muted, my friend. There we go.
This is another of the many confusing parts of this litigation. We've somehow gravitated away from the violation of not letting players benefit from their name and likeness to pay for play. And it's one thing to say you can't prevent a player from benefiting from their name and likeness. And it's another to say, as was stated, that we're creating a collective bargaining and we're going to share money. And as an old trial judge, what I wanted the chance to do was to have evidence presented on behalf of my client to show that we had ever prevented a player from benefiting from name and likeness, even before the Supreme Court said that. And we went back through our records and we found in 20 or 25 years, 2 players that had a chance to benefit off the court. One was a food coupon, and the other, someone wanted to give him $500 to subsidy publish a book. In a trial court with rules of evidence in place, you can't prove $3 million worth of damages to Houston Christian. And I suspect you can't prove $2.8 billion in damages. And just the fan in me that watches every Saturday, and I love it, loving it less lately. Look at the great players that have come through the state of Oklahoma with no name and likeness after it was legal. Spencer Rattler got to drive a car from a local dealership. That's what Lee Steinberg was able to negotiate for him. Caleb Williams had to switch schools to get paid. But the payment to the players when they switched schools was because of the name and likeness of the school. It was their desire to have the player on their roster that generated the money. Plaintiffs can't prove that these players would earn this kind of money in pure name and likeness with no boosters or collectives putting it together. It's just not real. But the settlements based on the overall structure of sports and the division of revenue, as was alluded to, like collective bargaining, it's not based on real damages. And the distinction between pay for play and name and likeness is completely getting blurred at this point in the litigation.
So we're going to talk about that pay for play here in a second, but Jayma, anything that you want to add to the piece just around this idea of throwing a cap into this settlement and kind of where does that fit into just where we are currently looking at not putting these limitations on student athletes?
Yeah, well, 2 things I would add. First of all, in order to get to collective bargaining, obviously we need to first have the athletes classified as employees. And I think that brings a whole host of problems, but I'm not totally
That's
saying
for another webinar.
that's for another webinar. So we're not going to get there. Yes, and if you have collective bargaining, you have an exemption from the antitrust laws here. But 2 things with respect to the cap. Remember, it's permissive. It's not absolutely required. So I would suspect that that would be one argument, that we're not setting a cap. It's just if you want to pay up to that amount, you can.
It's permissive in the pro sports too.
Yeah, okay.
Maybe.
Well, yeah. And there's case law that once you set a permissive cap, it is in effect a cap, and that's what you have to look at. The second thing is you can expect the NCAA, like they always do, is to have pro-competitive justifications for that limit, for that cap. And I'm not sure exactly, what they will throw into the pot here on those, but they may be able to convince a judge or a jury that there are sufficient reasons to preserve the product here of collegiate sports, that we need to have this type of a limit, and it's a reasonable limit, and there's no less restrictive alternative.
Yeah. So let's shift gears a little bit. I want to go to, we talked about how Judge Wilkin had a kind of a narrow view and didn't really get into Title IX, but some of the issues that arises. So let's actually talk about where she really did get hung up on some of the issues. And one of those significant issues really had to do with the idea of boosters and collectives and payments. And James just brought up this idea of pay for play. And so if we just, a lot has changed in college sports over a short period of time, but if we're honest with ourselves, 4 years ago, the phrase NIL collectives didn't even exist. Wasn't something that we ever even talked about. In fact, when July 1st of 2021, when name, image, and likeness went into effect, that first football season right after that, collectives weren't around, right? The first collective started to form after that football season. So now, though, collectives are most certainly part of the dialogue around college sports. And Judge Wilkin had a very significant sticking point regarding kind of the payments from collectives and boosters and this idea of having a valid business purpose for NIL as part of this settlement. James, I want to come to you and kind of talk about this. Can you share a little bit more about the actual issue there? And do you see that being resolved in this settlement? Do you, kind of how do you see this impacting kind of where we're at today?
Well, from the outside, which I am, because I didn't get to intervene, it seems in following the case that that's a real sticking point for the NCAA. That they want the money to be market sensitive, and they want it to be independently justifiable. And it doesn't seem like the judge or the plaintiffs are interested in doing that. So to me, again, from the outside, it looks like that could be a point that could blow it up, because again, there are people closer to it on the street than me, but this money is coming from friends of the university. It's coming from friends of the university that otherwise would be making significant donations to the university. And I'll leave everyone nameless, but there's a trucking company in the SEC that gives $1 million to every member of the basketball team. I can't imagine that's got a justifiable commercial purpose for the trucking company. It's clearly a booster deal. And if the NCAA sticks to its guns, I think that could blow the settlement up. But if the settlement gets blown up again at trial, you're going to have to prove damages, and you're going to have to prove damages independent of booster payments. And I don't, for the life of me, know how you can do it.
Yeah, well, maybe our economist here on the call with us, Andy, can shed some light. I'm curious from your perspective. You kind of talked about the asymmetrical side of all of this, but the financial piece is really fascinating, because it's not just the parties are not just the NCAA, the conferences, and the student athletes, but you have this now kind of third party that has come, to engage in college sports, called these collectives that are putting in a lot of money into this space. Kind of, what are your thoughts on the issues that Judge Wilkin has, and what are your thoughts kind of on how do collectives and boosters kind of fit into this as we go forward?
I think, again, stepping back and looking at a slightly broader angle on this, the NCAA, ever since 1955, when they legalized scholarships, has had a naming problem. They always had to find new names to justify the new activity that they're going to engage in. So they invented the name, or Walter Byers invented the name, student athlete. And now we have a new naming problem. What are we going to call these transfers that we're making to students? Are we going to call them pay for play? Are we going to call them NILs? Are we going to call them some other kind of financial transaction? And I think that's what is tying everybody up here. Underlying that is the issue that you brought up a few minutes ago, Luke, which is what's happening at Tennessee, where the AD said that he's going to introduce very significant ticket fees and student fees. Now, what about that? What should we think of that? Well, keep in mind that the median program in FBS, the last year before, that we have data from the NCAA that's not affected by COVID, the median school in FBS had an $18.8 million operating deficit. And that is without counting a lot of capital expenditures. So the actual deficit was larger than that. How does that get paid? How does it get paid? They raise student fees. And now we're going to have another excuse to raise fees. What it's doing is crashing down on the educational establishment in these universities. Will it survive? Who knows? Will it change remarkably? Yes, it'll change remarkably. Will we find new names to call it? Yeah, we'll find new names to call it. But what's happening with Wilkin is that we have a very myopic vision of what's going on in college sports. It doesn't look at the underlying finances of college sports. It doesn't look at the fact that college programs are tax exempt, right? And receive federal government subsidies. It doesn't look at the fact that 70% of our Olympic athletes are trained in our college system. It doesn't look at the fact that our college system produces for free football talent and basketball talent for the NBA and NFL. There's a whole ecosystem there. And are we going to try to reform the system based upon this very myopic and narrow view? It doesn't make sense. And one of the things will happen when you don't make sense is you have to find new names and new vocabulary. And that's what's going on.
Yeah, absolutely. And if you look at, you brought up, the mid 50s, early mid 50s, right? When scholarships were authorized, that's also the same time we saw the first television deal, right? And the first television deal was NBC, right? Covering one season. It was for like $1.14 million. My, how those times have changed in terms of the media deals that we're seeing, right? And so there's just this massive amount of money coming into college sports, and we do have to figure this out. Amanda, figure it out for us. Just kidding. As you are having these conversations with so many various stakeholder groups in this space, collectives, boosters, donors, fans, friends of universities have played a significant role in what this looks like, and that is most certainly kind of one of the hang-up issues in this preliminary or proposed settlement. What are your thoughts? What are you hearing kind of in terms of the future impact of these collectives and boosters?
Well, I mean, look, the collective operators that I speak with were telling me for weeks, and if not, months, and not just them, but lawyers as well, that they didn't think that, this proposed restriction was going to fly. And they didn't think it was going to fly with Judge Wilkin, which it didn't. And they sort of said, hey, even if it does fly with Judge Wilkin, the second there is an athlete who does not or is not allowed to do a deal, right? They submit a deal over $600, a proposed deal to this third party. We don't know who they're going to be, by the way, but they're chosen by the NCAA. So you can imagine, what side they're going to be leaning on. And they're going to have to come up with this nebulous, fair market value question. Andy, maybe they'll call you and have you create some sort of criteria for whatever that might mean. I was always told, the value of something is what somebody's willing to pay for it, but I'm not an expert. The athlete, the NIL collective, the third party company, well, specifically the collective, because the collective is not a party to this agreement, they're going to sue. And they're going to sue and on antitrust grounds and say, who are you to say we can't do this deal? Who are you to say this isn't fair market value? They're prepared to do that. So I don't think that this settlement, and they don't believe that even if this settlement goes through as proposed, which it won't, Judge Wilkin made that very clear, at least on this collective point, they don't have any intention of going away anytime soon. They don't have any intention of changing, the sort of power that they have over college sports, quote unquote. What they plan on changing is maybe making the deals a little bit different, making them look a little bit more palatable, right? But again, who's to say fair? And again, this is a question that I have for Andy. Who's to say that fair market value isn't just what somebody's willing to pay? And then I just wanted to make one other point and maybe just be the contrarian of this panel, which is, again, all of these conversations, and I tell people this all the time, all of these conversations that are being had are about what do I think is best for the future of college sports? What do I think is best for the future of my university, my school, my conference, my football team? That's not the purpose of a court of law. The purpose of a court of law is to settle a legal dispute. The purpose of this settlement is not supposed to be college sports. Like, what is settling the future of college sports? Let's put as many things in there that are going to be the best things for college sports. No, it's to settle a legal dispute. And if you think that the NCAA and the conferences that are defendants are trying to put things into this settlement that are, quote unquote, what's best for college sports, you're naive at best. They're putting things into this settlement that are going to protect their business model and protect them from future legal liability. That's what their goal is in solving this dispute. It's not what's best for college sports. Same on the plaintiff side, right? I mean, Jeff Kessler and Steve Berman can talk all they want about how they want to make college sports better for everyone, but ultimately that's not their job. Their job is to get as much money for their clients as humanly possible, right? And themselves. And can you blame them? So it's the same answer that I give when people say, well, should athletes be employees? You know, should the courts let the athletes be employees? Well, it may not be up to anybody who actually cares about what college sports should look like in an ideal world. It's about what the law says. So I just want to keep that in mind when we have these conversations, especially with regards to this settlement, because everybody's acting like, this is a negotiation over how we should make college sports look. No, it's a negotiation about liability and money. I'm going to mute myself now.
Can I jump
No,
in
I
on
think this is great. And Andy, I'm going to kick it over to you because Amanda brings up this idea of fair market value and say, she said specifically, what's to say that if I'm a business owner, a wealthy donor to my institution, if I want to say that I'm going to give $500,000 to athlete A because athlete A has a bunch of followers on social, but really I want them to come to this institution so we can win a championship. And I want them to put out 2 posts on Instagram. What's to say that's not fair market value? I'm the market. I'm the one with the money to saying that I'm going to pay it. What's to say that's not fair market value?
So fair market value is what somebody's going to pay. It's the transaction that happens in the marketplace. The question is, what are you buying when you put out fair market value? Are you buying roster value, or are you buying advertising value? And what the NCAA wants it to be is advertising value, right? They don't want it to be roster value. Means how productive are you on the team? And then it's pay for play. You can call it whatever you want, but that's what it is. So that's what the issue is. I don't think the issue is fair market value or not. It's what is being allowed to be remunerated here. And if you have a rule that's around amateurism, then you don't allow roster value to be remunerated. So that's the fight goes back to that. One other thing here, Jema mentioned at the beginning that the settlement was for $2.78 billion going to the athletes. Keep in mind that $2.78 million does not go to the athletes because Jeff Kessler and Steve Berman are going to take their bite out of the pie. They're going to get about $500 million. That's not completely finalized yet, but their law firms and their experts will be taking a big chunk out of that $2.78 billion.
Wait, you mean they're not doing this for free? Oh, okay. Just wanted to make sure. Jema, go ahead.
One other thing that I would like to point out that further complicates all this is what happened in Georgia yesterday or the day before, where the Governor Kemp, signed an executive order saying that schools in Georgia now cannot be punished by the NCAA for facilitating compensation to the athletes or directly the schools compensating the athletes. And there are absolutely no guardrails or limits in that. So I suspect, just like what happened with NILs a number of years ago, that more and more states are going to pass that, in order to stay competitive with Georgia.
So what we need is national legislation.
Exactly.
Which is
Congress to reshape the industry, not one antitrust lawsuit.
So it is interesting. And I think Amanda has brought that up with fervor, right? Which is, hey, we're not trying to solve every issue of college sports through this settlement. And so many people say that that there should be federal legislation, right? We know that the NCAA, the conference commissioners and leaders have been pushing for this because the other piece is in this proposed settlement, and somebody raised it, I can't remember who raised it, but there's no ongoing legal protection for the NCAA through this proposed settlement. Right. And so there's a lot of discussion about, should there be an antitrust exemption for the NCAA, protection and safe harbor from future lawsuits, et cetera. Jema, I want to come back to you on this. Right. You raised the point about potential federal legislation. Right. Where do you see that playing a role in all of this? We have this massive kind of proposed settlement. It's going through the process, and you kind of laid out the process a little bit at the beginning. What are your thoughts in terms of how federal legislation could play a role here?
Well, I would recommend that the audience read Andy and my law review articles on this issue, where we have proposed for many years now that there be a limited and conditional antitrust exemption that would have limits on coaches' salaries, on facility spending, etc. So it would be narrow to address the actual problems. And now, you know, it could also limit the or have guardrails with respect to how much athletes are paid and whom should be paid. You know, there are a number of bills floating around that also deal with the Title IX issues. Federal legislation could make it explicit there too. Federal legislation could make it explicit that the athletes are not going to be classified as employees. I mean, Andy can expand on this probably much better than I as to what ideally you would want to put into legislation. You know, it should be a holistic study of what we've decided in America, that we want athletics to be part of our educational system. So how do we bring it back to the educational mission? Or do we just let it, you know, fly out and become minor league again for NFL or the NBA? Now, is it realistic? You know, for years we've been pushing this, but I don't know if we're any closer. Clearly not before the election. And you know, it's anybody's guess as to how realistic it is. I think that if the proposed settlement goes through and there are still a ton of problems with it and objections to it, then perhaps Congress is more likely at that point to step in.
Yeah, I'll say, Andy, I want to come to you next, but I'll just say to your point, Jama, we've had since the beginning of name, image, and likeness in 2021, we've had over 12 bills introduced, and not a single one of them have gone to a vote. Not one. I do think that the student athletes as employees categorization question, I do think that could be that catalyst for seeing a move on Congress. But Andy, what do you say in this? You co-authored the law review article with Jama. What do you say to this?
Well, let me say a few things. Back in the 1970s, we had an amateur system and an Olympian system that was a complete mess, and it was corrupt. And what happened was Congress created a commission under Ted Stevens, senator from Alaska. They created a commission to study amateur athletics and Olympic athletics in the United States. And they studied it for a few years, and they put out a holistic vision. And out of that vision came the USOPC, US, or used to be called USOC, and the whole system that we have now for Olympic athletics. And I think that's what needs to happen here. There needs to be a congressional commission, could be a presidential commission, that brings experts together, studies the system, looks at all of the goals that the system has, and tries to coordinate the implementation of programs that will facilitate those goals. You know that just like everybody else, I'm concerned about the exploitation of athletes. The athletes who get exploited financially in our current system are the ones who eventually are going to go on to the NBA and the NFL. And they're, by the way, they're less than 2%. They're less than 2% of college football players and college male basketball players. The other more than 98% get dragged into this system where they're robbed of the education that they're promised. And I think that the first step that we have to take is, if we're caring about exploitation of athletes, the first step we have to take is to give these athletes what we promised them, which is a robust, meaningful educational program, so that for the next 50 or 60 or 70 years of their lives, they can benefit in the workplace and socially from that education. And it's not what a very small number, a very small percentage of athletes are going to get paid when they're in college, when they're about to go to the pros and get whatever, $2 million, $10 million, $20 million a year.
Yeah, absolutely. So just fascinating, right? I mean, we could go for hours on these topics. We only have about 30 minutes left. We have a whole bunch of questions that have come into the Q&A. We're going to hit some of those and follow up on some things that have been said. So I will say for all of those who have joined us, if there's an absolutely burning question that you haven't had answered yet, feel free to put it in the Q&A. We'll try to get to it. No promises, because there are already a bunch of questions there. Now, one of those questions says, do any of the panelists, so we'll start off there, just saying this is open to all of you. Do any of the panelists see a problem or rationale for roster limits for softball and women's lacrosse, which have been reduced compared to their male counterparts? So women's lacrosse at 38, men's lacrosse at 48. Anyone see a problem or rationale for those roster limits for things like softball, women's lacrosse?
Well, remember,
Go
Title
ahead,
IX doesn't compare sport by sport, team by team. It takes an overall view. And so I don't know specifically what the issue would be with respect to the reductions and what the rationale was between the reductions and the increases. But importantly, under Title IX, the schools must still have, equal opportunity based on the undergraduate enrollment. So I don't really have a problem with the specific teams, women's teams being reduced, as long as overall the opportunities are the same.
Andy, anything to add on that one?
Yeah, no, I was going to say the same thing.
Okay.
Absolutely. I mean, and there are a few issues there. If the women are underrepresented with athletic opportunities, and you want to add some sports, it's got to be, you have to find a sport, number one, that your student body is interested in and experienced and able to play, but also that sport has to be something that's available in your region or available in your conference. And so it might be the case that you're 1 or 2% below the number of students. But I agree with Jema entirely. It's not up to us to decide whether the softball limit should be 25 or 35 or whatever that number is, as long as they're providing enough opportunities for women to meet the needs and the abilities of the women.
Yeah. James, I want to throw this next question to you, and anyone else feel free to chime in. But we know that there have been numerous lawsuits in the past specifically about scholarship limits and eliminating scholarship limits. Now, this has become part of this proposed settlement. And the question is, that's been posed is, do you think that scholarship limits could be eliminated whether or not the House settlement is approved? The writer goes on to say, it seems like an easy, no-cost change by the NCAA where schools could just decide whatever they want to do with each particular team. Any thoughts from your perspective on if those scholarship limits could just be eliminated regardless of what happens with the settlement?
It's a great question. And I think it's possible, but again, that doesn't mean litigation will ensue. And it goes back to the problem with the House settlement. And I don't mean to be naive, but I am. If whether the House settlement resolves intercollegiate athletics or not, or whether it just settles the damage claim being made, it can't do either without everyone at the table. And everyone is not at the table. And the reason they're not, and it's plain and simple, if the membership voted by a 2/3 majority, which is what's required to settle this case, it would not be settled. So the NCAA and the plaintiffs have from day one rocketed this along. They have excluded people from it. When we filed our attempt to intervene, we were told by the NCAA and the plaintiffs we were both too early and too late. We were too early because there really hadn't been a deal very long, but we're too late because there was a deal. And we found out about the deal because it was on the plaintiff's lawyer's website, May 28th. And everyone but the Power Four was excluded from meetings and not told what was going to happen. So again, whether we just settle the damage claim or whether we reform the world, it's not going to happen in the House case. And the inability of it to happen is going to wreak havoc for the next 50 years, because all you need is court costs and a law degree, and you can have 10 years of litigation, and I'm a lawyer. So anyway, it's a great question. I don't think it's able to be solved.
Yeah, that's a tough one. Amanda, want to bring a question that was actually raised directly to you, and it just asked, are you hearing any ideas on how the NCAA or conferences or schools will try to evade Title IX for past damages? What's being suggested? What are you hearing? Love to hear what you're hearing out there. And then Jamie, I'll come to you after that just to get your thoughts on that same question.
Well, for the past damages portion of it, not really, because like, the schools or the conferences in the NCAA, and the rest of Division One are going to have to pay what they're told to pay or what they agree to. It's more the injunctive relief section of it that I'm curious about. Um, it's funny, maybe like a month and a half ago, there was several SEC coaches who were like, yeah, we plan on giving 75% of the house settlement money to our football players. And my editor sent me the headline and was like, oh, we should write about this. Like, this is big news. And I said, actually, it's not, because I don't know where they got that idea from. Because first of all, they're not in charge of the football coaches are not in charge. Second of all, that's probably going to be some sort of Title IX violation, right? Because the rest of the male and female athletes are going to get 25% of like, that doesn't make sense to me. So to answer the question, like, I haven't been hearing anticipatory ways to sort of like in the dark room be like, let's see how we can evade Title IX. But I have heard some assumptions made by folks in athletic departments about, yeah, we're, all the money is going to go to football players because, like, obviously, and whether it should or shouldn't, not up for me to say, but that's definitely something that has been tossed around, at least in the media. I can't speak to whether or not those are legitimate conversations or if it was just a coach on a media call being like, yeah, this is what I expect. Like, you know what I mean?
Yeah. Jamie, your thoughts on that.
Well, I think there are a couple of ways. Well, first of all, I would like to distinguish between the past damages and injunctive relief, because we're hearing, I have not heard any conference or school say that the past damages should be subject to Title IX. I've heard a few experts say that, but not the schools. On the other hand, with respect to the future, through the injunctive relief, I've heard more conferences and schools say, yeah, it should apply. Although a lot of them are flip-flopping now based on what, their big competitor is saying. So that's up in the air too. I think one of the biggest arguments that I've been hearing for not applying Title IX to the past damages is it's coming either from this fund, which the plaintiff's lawyers are going to be managing and distributing the money, or it's coming from the NCAA. And the argument is that neither of those are subject to Title IX. You're subject to Title IX if you're an educational program and receive federal assistance. I think it's just a subterfuge. You have to look at what are the payments and who are they going to, and what are the payments are for something that the school would have otherwise paid. It's not like this fund otherwise would have been created without there being any school involvement in the whole process. And there are definitely arguments and people looking for cases to bring against the NCAA that the argument is that there is this controlling authority theory applies to the NCAA. It's been applied to hold state athletic associations responsible under Title IX, and also that the NCAA is just comprised of the schools. They're one and the same. So there are strong arguments, or at least there are arguments for holding the NCAA responsible under Title IX.
There's also the Civil Rights Restoration Act of 1988 that has language also suggesting that.
Yeah, absolutely.
And then the other one that they're going to argue is the revenue based. It's all revenue based, and therefore, like in Title VII and the Equal Pay Act, where you do have a defense based on revenue share or market realities, that the argument I'm hearing is because Title IX is fashioned after Title VII, therefore there should also be a defense. But again, Congress has been very, very clear, as has the OCR, that revenue sharing sports are not exempt from Title IX, and there's no such defense. But that doesn't mean it won't be made.
Sure, absolutely.
To
Well,
me, Luke, there's a really interesting clash here that underlies our whole discussion, which is that Title IX is based upon the application of gender equity within an educational system, within an educational framework. And the other discussion is about a commercial framework where people get paid according to their marginal revenue product and according to their market value and so on. And those two systems don't mix. And so somebody has to make some choices. One choice might be, and Jam alluded to it earlier, if you're really hell-bent on giving the athletes money, for the top athletes, for the value that they produce, why don't we turn it into minor leagues and stop the pretense of putting this under an educational umbrella?
yeah. Well, interesting, right? So let's dive deeper into that. There's a question that I think kind of fits along those lines, that if we say, okay, do we just make this into some minor league or what have you? But let's take a step back for a second. There's a question that says, once there are settlement parameters, right? Once a settlement, let's just say if a settlement, which I'm going to come back to your thoughts on this later before we wrap up, if a settlement does actually get approved and is implemented, who does the panel, and I'm going to ask each of you this question, but who does the panel feel should be responsible to enforce then those rules and impose those accountability measures? Is it the existing NCAA framework, NCAA enforcement, and their infractions process, or is it a completely independent service and process? Is it a government agency oversight? Is it just a third party kind of? Who do you all see from your various perspectives that should be then responsible for making sure then that all the parties are sticking to the rules? James, I'm going to go James, Amanda, Andy, and Jama. What do you think?
Well, it's a great question. I think it has to be an arm of the court. Not to bring up memories of the special master in the Florida case, but it's got to be someone that the attorneys can't sue. It can't be someone that the attorneys can ignore. So I think the judge has to create some kind of special master or committee and take the burden of enforcing it, because this will lead to, again, decades of litigation unless there's some kind of immunity built in it.
Yeah. Amanda, you're talking to a lot of people in this space. What are you hearing? What do you think in terms of who should actually enforce this should it get approved?
Well, nobody that I talk to thinks it should be the NCAA, for the simple reason that no one thinks the NCAA should be in charge of anything anymore besides the NCAA. Unless being in charge means, taking on, litigation and legal fees, in which case the entire ecosystem is happy to let the NCAA do that for them. I'm not sure I have a better answer to this question. I'm sure everyone on this panel will have a better answer than me. I think I'll answer the question with a question. I feel like it needs to be, on the one hand, similar, does it need to be similar to how a collective bargaining agreement is overseen with, the two parties and a third party arbitrator, or should it not be that? Because as we've talked about, this isn't a collective bargaining agreement. I think a government entity would probably require some sort of law from Congress. That is not going to happen based on my sourcing, just to bring that back. I do think there needs to be some sort of third party arbitrator involved, could be someone legal, or it could be just the idea that you could bring something back to court, but definitely not the NCAA and not the conferences.
Yeah. Andy, your thoughts? Who's going to make all this happen?
The question is above my pay grade. Give me $495 million and I'll give you the answer. No, frankly, I think that if the settlement is approved in roughly its current form, that it's unenforceable. And so I wouldn't make a pretense at it. We can spend the next hour or so about all of the conundrums and complications and mixed signals and tax questions that will overwhelm this whole new system that will come out of the settlement. That I don't think it's enforceable. If I were forced to pick a method, I would go with what James has said, but I don't think that's really workable.
Jema, your thoughts?
Well, the NCAA cannot enforce without subpoena power. They have no subpoena power. How do they require, the third party emails, etc.? They cannot be in charge. I actually think that the Federal Trade Commission is a good option. It was, suggested in a couple of the bills. I spent a couple of years after law school at the Federal Trade Commission and investigated for a whole year the funeral home industry. And we came up with guidelines. We had a holistic solution to what should happen there because people are being cheated left and right. But you've got a structure in place. You've got administrative law judges. You've got attorneys working in the area. You've got subpoena power. There has to be increased spending, no question about it. There would have to be an office established at the Federal Trade Commission that would focus on college athletics. But I think that's a reasonable solution.
How would that happen, though? Would the court appoint the FTC to do it?
Well, I don't think a court can appoint that. Congress would have to get.
So you're falling back on we need Congress, and Amanda tells us that can't happen.
But it could be part of the funding, the appropriations for the Federal Trade Commission as opposed to a separate college bill. I mean, I'm not an expert in this area, but I would think that might be a way to do it. And now a lot of these practices that we're talking about are unfair and deceptive, practices, which is what the Federal Trade Commission has jurisdiction over. There's a
They would have to insert themselves.
Profit. Yeah, exactly. So it's complicated.
I think that's a great theme for this entire conversation. It's complicated. So I want to ask one more question, and then we're going to wrap with predictions. Right? What a great place to end with predictions and thoughts. But first, James, I want to get your thoughts because one of the things that we haven't talked about is around just process. Right? So process says that once you do get preliminary approval, if you do, then the next is that there's a process for opting out, right? And that opt-out period, usually not at least 90 days, I believe, right? So you've got that opt-out period, and there's a lot of conversation of will people be opting out? Will student athletes be opting out? Can schools even kind of opt out of this? What does that look like? And what are your thoughts on what you see kind of happening should we get to that point where there's an opt-out period?
It's a very good question, and I love the description as complicated because it's true. I think there's several stages. There could be opt-out, but I also think you'll see significant enforcement issues arise. The South Dakota Solicitor General and Attorney General have already filed to prevent the judgment from being enforced. There are 4 or 5 other attorney generals who were very close to intervening with us until we got thrown out. And for some reason that I'm not clear of, both the court and the attorneys on both sides ignored the Antitrust Reform Act that Chuck Grassley ran years ago, and none of the attorney generals were notified of this settlement, which means they could bring that up and delay the settlement until they were notified and had a chance to participate. So again, it's complicated. I don't know how this judgment ever gets enforced. I just don't know any state trial judge that's going to enforce a judgment that was entered into without the authority of the institution that reached it. That's just basic first-year law school. So, and it's also hard to predict trends with higher education because people kind of flock together. Very few people step out and try to opt out or go a different direction. Hence, only 2 schools have filed a lawsuit so far in this case. Anyway.
Yeah. So I want to dig a little deeper because you said something, and I think it's important for non-lawyers who are listening to this call to understand. Again, we can go back to civil procedure and all the fun things that we did in law school. But in particular, you talked about a couple state attorneys general, right, who could intervene. it's been said, right? I think you mentioned South Dakota, Montana, maybe there are some states that have said, hey, if this gets approved, someone could appeal through state court. And the person who's listening might say, well, wait a second, this is a federal case. How is somebody getting involved from a state court perspective? Maybe expound on that a little bit to help people understand how state attorneys general can play a role in this federal court case.
Well, not only a state's attorney general, although that's really probably the most significant because of the power they yield, but any school could go to district court wherever they're located or have played and say there's an invalid judgment that's trying to be enforced. And in fact, the judge in this case invited Houston Christian to take up the issue of no authority of the NCAA to settle somewhere else, but not in front of her. So we kind of perceive that as an invitation to do just that. From the sports perspective, maybe the best quarterback in this game is Marty Jackley, the Attorney General of South Dakota. He is one heck of a trial lawyer. I would put him in front of anyone on the plaintiff's team. And he's going to try this case in Brookings, South Dakota. And again, he's got a very pure client because other than the quarterback of South Dakota State, there's not a lot of name or likeness going around South Dakota and South Dakota State. And of course, the quarterback of South Dakota State was a great sports story. He turned down $2.5 million to transfer with his quarterback coach to Northwestern and stayed to graduate. And he got some local stuff. So I think theoretically, depending on the courage of the institutions, you could see 50, 60 lawsuits. And let me qualify that with, you don't see much courage in litigation with leaders of higher education. Most of them don't step out of the box and risk it. Most of them go along to get along. And that's why we're here today.
Yeah. All right. So in the time that we have left, I'm going to ask for each of you, you can make your 90-second close, if you will. And what I'd like is a quick prediction, and then you can use the balance of your 90 seconds for anything else that you want to add. But predictions on maybe 2 or 3 levels, right? 1, does this proposed settlement, actually get approved? 2, if it does it get appealed? And then 3, is this settlement going to really go into effect in the fall of 2025, which many people have said that if, timelines, everything passes, that we'll see this change happening fall of next academic year. So maybe I'll start, Amanda, with you first, then we'll go to Jama, we'll go to James, then wrap up with Andy. And then I'll give my 2 cents if we got some time. Amanda, what do you think?
I think whether or not the settlement is going to be approved, I think we're going to figure that out in the next couple of weeks, because if Judge Wilkin is not going to be cool with this NIL collective restriction, then it sounds to me like it's dead in the water and we go to trial in early 2025. Supplementary prediction, I think that we will get some sort of, at least, I'm sure it will be appealed, but a ruling either from the USC case at the National Labor Relations Board on the misclassification of, athletes as amateurs rather than employees, or from the Dartmouth case, whether or not the national board is going to take up the appeal about whether the Dartmouth basketball players are employees. And then the third thing is, I think we'll also probably get a general election before the settlement. So we'll get an indication based on, all the sourcing that I have in Washington suggests that, like, if there is a possibility of getting some sort of law, at least an NCAA, friendly-ish law, we're going to need probably to have a Republican sweep. So we'll see how that goes. But I think all of those 3 things are probably going to happen before at least the full House settlement it gets rubber stamped, if it does, which I'm not sure it will.
All right. Thank you so much. Jama, coming to you, your thoughts and predictions.
Well, One thought I do have, an unknown that's on the table right now, is how many athletes will in fact opt out. We haven't talked about the Fortno case, which is pending in Colorado. There are other cases out there, and you've got a group of women now who have objected to the settlement. So there could be a lot of women potentially opting out, and Judge Wilkin will be very hard pressed to prove the settlement if the opt-outs are too great. So I'm going to predict that potentially she won't be able to find that the settlement is just, reasonable, fair, adequate. And those are the standards she has to apply. I also am going to give you a prediction, a novel idea, that our next VP of the United States, Coach Walsh, will lead a bipartisan effort for there to be a congressional bill that will solve all our problems.
Okay, well, this is being recorded, so we'll be able to see if your prediction is accurate. James, we'll come to you. Thoughts, final thoughts.
Well, I can't get the Vegas betting line on it because it's complicated, but I think it will have a totally unexpected event. I don't know whether it'll be approved or not, or whether the event will happen after the approval or not, but this is too complicated. There's too many people with diverse interests, and there's too little consensus to achieve fundamental change. And I think something's going to blow, and I don't know what it is.
All right. Thank you so much. Andy, your thoughts?
Well, Jema and I have been working with some other people over the last several years, talking to members of Congress and their staffs. And there is a lot of discussion that's crossing over the aisle. And I think we're going to get some new blood in Congress, and also some sense of greater rationality and purpose in Washington. And so I'm going to go with Jema. Vice President Walz will bring the sides together and promote a step forward and a new vision for intercollegiate athletics, which it desperately needs.
Okay. Well, I'll go with the prediction, and my prediction is this remains complicated. I don't see us actually getting to this settlement being approved, which is why I always try to refer to it as a proposed settlement, because it is just that. It is a proposed settlement, and I think it does try to achieve way too many things that have too many diverse issues and diverse perspectives on, that make it much too challenging for just this settlement to address. So with that, James Bryant, founder, chairman of the National Litigation Law Group, Amanda Kristovich, a reporter from Front Office Sports, Jema Meyer, counsel for Simpson Thacher and Bartlett, and Andy Zimbalist, the Robert A. Woods Professor Emeritus of Economics at Smith College. Thank you all so very much for your time, for your perspective, for your energy in this conversation. Unfortunately, our time has come to a close. So panelists, all of you, thank you so much for your insights.
Thank you,
and
Luke.
comments.
Thank you, Luke.
Well, thank you.
Thank
Thank
you
you
all.
very
Thank
much.
you.
Thank you. And for all the attendees, thank you so much for joining us, and thank you for sharing your questions. I hope everybody has a great rest of your day as we figure out the complicated things. Thank you so much.
Thank you.